It's great to have you with us today for today's data.europa Academy webinar. We will give everyone a brief moment to join. In the meantime, feel free to say hello in the chat and let us know where you are connecting from. For those that are also joining us for the first time, it's your first webinar with us. My name is Flora Copello and I work at the Publications Office of the EU on data.europa Academy, the Learning Hub for Open Data. Wonderful. I see many of you coming from Italy, the Netherlands, Belgium, Sweden, Moldova, Luxembourg. Great. Wow. So nice to see so many of you joining today. For today's session, I will skip the lengthy introductions that I normally take, as we have a very packed agenda and some very interesting presentations from our expert speakers. I'm very curious, I'm sure all of you are, to learn more from them. And as you have probably guessed from the title of the webinar, we will take a closer look at the latest developments in the European data policy landscape, the recently adopted data union strategy and the digital omnibus regulation. We will also then turn to the findings of a new cross-cutting study evaluating how three key instruments, the Open Data Directive, the Free Flow of Non-Personal Data Regulation, and the Data Governance Act are working in practice. And before we begin and give the floor to our expert speakers, just a few practical notes. This session is being recorded. The recording and the slides will be shared with you and will be made available on data.europa Academy, and you will receive them on a recap mail in the upcoming week. At the end of the session, please take a moment also to stay and fill our short feedback survey. You will see the link appearing and a QR code, and I will remind you as well when we are wrapping up the session. And as always, feel free to post your questions in the chat at any time. If you wish, you may also mention the name of the speaker your question is addressed to, and we will make sure to gather them for the Q&A at the end. And because, as I mentioned, we have a very interesting and packed agenda today, we may need to extend the Q&A slightly to answer as many relevant questions as possible. So if you're able to stay a bit longer, that would be great, and we would really appreciate it. If not, as we mentioned, we are recording the session, so you will receive the recording and the slides in the upcoming days. And now, to the best part, introducing our speakers. We are very pleased to welcome Jirka Pilar. Jirka is a legal and policy officer in DG CNECT's Data Policy and Innovation Unit. He works on emerging data policies such as a non-personal data access and reuse, and supports the implementation of the Open Data and PSI Directive and the regulation on high-value datasets. He will present the data union strategy and its policy priorities today. Then we have Tania Velcsov with us. Tania is a junior legal consultant at Spark Legal and Policy Consulting, specializing in legal research and policy drafting. She has contributed to the EU studies for DG CNECT, DG Taxud, DG ENERD, and OLAF. Following, we have Giorgia Spolverato. Giorgia is a public policy analyst at Open Evidence, working on projects for DG Sante, DG HERA, DG CNECT, the Council of Europe, and Eurofound. She has recently contributed to studies on systemic risks of very large online search engines and the implementation of the Data Governance Act. And last and definitely not least, we have Amanda Brincat with us. Amanda is a senior data security and EU policy consultant at Capgemini Invent, focusing on EU legislation, AI security, and digital governance. She has worked on initiatives for DG Home, DG CNECT, and DG Grow, supporting policy innovation and digital rights. To guide you through today's session, we already started with the short introduction. Then we will give the floor to Jirka to introduce us to the data union strategy. And then we will have the study on the free flow of non-personal data regulation, Open Data Directive, and Data Governance Act from Tania, Giorgia, and Amanda, and we will finish with the Q&A session. Before giving the floor to Jirka, a A reminder to all of you that just joined, we are recording this webinar, and the recording and the slides will be shared with you during the upcoming days. And with that, let's begin our program. It's my pleasure to give the floor to Jirka, who will guide us through the data union strategy.
Good morning. I hope you can hear me.
Yes.
Great to be here with you this morning at the data.europa.eu event. I come from DG CNECT. It's the part of the European Commission that was behind the creation of European Data Portal, and we are until today closely cooperating. So it's a great chance also to let you know about quite a fresh development in data policy, which is the data union strategy, and a related legislative proposal called the Digital Omnibus, which were both presented to the public last Wednesday on the 19th of November. So let's go straight to today's program. The new data union strategy is a, let's say, continuation of a data strategy that you might have heard of, which dated from 5 years ago. But of course, the situation has developed over the last 5 years quite intensely, even though everybody knew about artificial intelligence at the time already. Well, the pressure that the AI is currently representing on policies, on the economy or societal issues has grown significantly. So this new strategy has to react to that. Also, the regulatory landscape has developed significantly. There have been many new regulations adopted by the EU over the last 5 years. So the strategy is taking a look at that as well. And lastly, the geopolitical situation is not the same really as it was over the last 5 years or 5 years ago. And again, there's something that data can influence, and the EU should focus on this aspect of geopolitical politics as well. And data in the EU is something probably that we still would like to be governed by our own rules and by our own values. The data union strategy has 3 main parts. The first one you will notice is something that we have already been working on a lot over the last years. That is to say, to increase the availability of data across the EU economy so that there are some new uses of the data, some new insights, new services, new products being made from the data. The second important part of the strategy is looking at the legislation. As I said, there have been a number of new regulations, and they are sometimes creating a landscape that is not always easy to navigate for those who should apply the rules. There should be probably a bit more simplicity, clarity. Some instances would need to be more effective, more innovation friendly, and also smaller companies based in Europe and being born in Europe should probably receive a bit more help through the legislative means. And lastly, but not least importantly, is the position of the EU with respect to international data flows. Here, Europe will be defending its position of being an open continent, but at the same time assertive towards the rest of the world, aware that the international data flow needs some management, that the sovereignty needs to be safeguarded, but at the same time, the flows should be made possible wherever they can help and wherever this does not endanger the EU's interests. Now let's go over the main pillars quickly. The first one is looking at more data being used where they can make a difference. Well, you have probably heard over the last couple of years about European data spaces. They will continue to be developed. They will be further supported. And one of them, which was not so much in the center before, will be launched. And by that, I mean the European Defense Data Space. And all these data spaces will continue what they were created for, well, creating an environment for data sharing, for data processing, putting companies and people together and institutions together that have interest in reusing data, for building something with the data, and using infrastructure that they have together, and of course respecting the rules that either the EU set up or the data spaces set for them for their practical, concrete sectoral needs. And the data spaces will need to be linked to AI ecosystem. That's why there are data labs coming into play, and they will give access to high quality data sets, which you can usually find in a data space, but they will also help the AI creators to get compliant with EU rules. They will offer further tools for data pooling, etc. We also need infrastructure. That's why the Commission will work on a proposal for Cloud and AI Development Act, which will be in place to make conditions for better development of cloud infrastructure and all the necessary hardware in the EU. And last but not least, what you need for AI development is good and quality data. Here, the Commission will continue its policy on high-value public sector data sets, and we will be next year working on defining some new thematic categories such as legal, some scientific data, probably also data from languages or from the public sector on public procurement. For better availability of data, the main tool are the data labs, which will be focusing on several of the points that are shown on the current slide. For example, they will help with availability of synthetic data and with the generation of the data and making sure that it does not reveal some sensitive or confidential information. And they will also help with guiding data users to be sure that their data sharing does not present any risk regarding, for example, personal data, or when competitors share data, to be sure that they are in line with the competition law. And it will provide further advice to be sure that companies do not refrain from data sharing because they are afraid of some regulatory risks. Standards are also still in the spotlight. The Commission will launch a few standardization requests for quality, but also standards regarding annotation and labeling to make data AI ready. If you look at the second pillar of the strategy, that's the one looking at the regulatory landscape. And here, also thanks to the colleagues who are presenting today as well, who helped us evaluate several legislative instruments. We were in the position already now to propose some legislative changes, such as the consolidation of the rules on sharing public sector data and private sector data. Also, we were able to modernize the rules on cookies, which are currently in the e-privacy directive. There were also a couple of amendments to the GDPR that were presented. and also several relatively small measures that were added to the regulatory landscape to make life of small and mid-cap companies, which are mostly European, make their life easier, and they are reusing data coming from various sources. And lastly, quickly about the last last pillar of the data union strategy, and it concerns the international data flows. So as I said, the EU will still remain an open continent, but it needs to remain open with regard to trusted partners, and needs to ensure security and fair exchange conditions for data. There will also be the need to tackle some geopolitical tensions with some global rules, and that's why the Commission will build on its digital strategy, which was published already in June this year, and deepen the digital partnerships that are already taking shape, and tackle data governance questions, and especially with the partners with whom that we can share some common objectives. And you can see that in the free trade agreements, the digital clauses, digital provisions are quite a common sight nowadays. And normally the Commission is requiring from its partners the similar or the same level of openness as it is practicing itself. So the data union strategy is very mindful of all these geopolitical dynamics, and will continue to protect personal data of its citizens, of course, but also trade secrets, while promoting the data flows globally. So there will be some more to come also in this area next year, to be sure that data, sensitive data, or copyrighted data, intellectual property data of European companies remains within the EU and governed by EU laws. Now let's go from the strategy to a current newest legislative proposal that the Commission put forward last Wednesday as well. Now it's got the name the Digital Omnibus because it concerns a number of regulations and directives. Some of them are being changed, some of them are being even repealed. And it's a reaction to the necessity to have clear and coherent rules if the EU wants to effectively implement them. So that's was the reason behind the Digital Omnibus. It is, for the most part, not some deep change, substantive change to the rules. It is rather a critical look at the legislation, which was motivated by ensuring effectiveness and innovation friendliness rather than total makeover of those rules. So what you will see mainly is cutting some redundant provisions or obligations that led to some high administrative costs that were not really justified at the end. Some provisions making it easier to get compliant with the regulations. As there is some reduction in some obligations concerning reporting, and the focus is on competitiveness. In concrete terms, we don't have time to look at everything in this proposal, but if I manage to get to another slide, we can have a look at what's in it. Of course, the data rules, which we will be speaking about. It also concerns cybersecurity, platform to business, and Artificial Intelligence Act is being touched upon by the Digital Omnibus as well. But since we have experts on data here, and data is the main focus of the data portal, not surprisingly, let's have a look at what the Digital Omnibus brought about regarding data. So you probably know there is a regulation called the Data Act, which is the youngest of data-related regulations. There is also a regulation called the Data Governance Act. And it seemed to make sense to bring all these provisions regulated in the Data Governance Act to the Data Act so that they are all in one space. There is also the Open Data Directive, which is the oldest piece of legislation dealing with reuse of public sector data. And it made sense as well to make these rules part of the all-encompassing Data Act. And lastly, there's a regulation on the free flow of non-personal data. That one turned out to be in large part already replaced by the Data Act. And also it turned out to be a candidate for a significant reduction while keeping the main rule in place. And this rule is also moving to the Data Act. That's why we can say that out of 4 pieces of legislation, there will be one consolidated Data Act dealing with all aspects of data sharing, and not only with the public sector data, but also with private sector data. As I mentioned, the free flow of non-personal data regulation, the main rule there is that member states should not put in place restrictions on data localization. This principle remains in place, but a lot of administrative obligations concerning member states are proposed to be repealed. So this instrument will conserve its main rule and effect without creating a number of burdensome obligations on member states around it. Now, the rules on public sector data, which you can find a lot on data.europa.eu portal, both the open data, but also the data that we call protected data. So it means the data that only will be revealed to a concrete reuser under very concrete conditions for a very concrete purpose. So all these rules were scattered across the Open Data Directive on the one hand and Data Governance Act on the other hand. And the Digital Omnibus proposes to consolidate these rules and make them all part of the Data Act, which would make it also easier for member states to look at all these rules as a one whole and decide which ones to use in each case. The next part of change to the data landscape concerns the sharing of private data with the government. Private actors often were worried that they would need to share too much data in too many different situations, and that the data would not be then protected, whatever the government will get its hands on. That's why these rules on B2G data sharing are now limited only to really public emergency situations where there is no other choice for the public sector how to get to the data. And since we talk about changes to the Data Governance Act, Open Data Directive, Free Flow of Data regulation, all these changes were based on evaluation that we did over the year, and also a number of public consultations, but mainly looking backwards. Now, on the same day that the strategy was presented and Digital Omnibus was also proposed, on that same day, the Commission also launched an exercise called Digital Fitness Check. So here you can expect that we will be looking more closely at the substance of different regulations, and with also more time available to us. We can have a deeper analysis of the digital rule book and more time to discuss with the stakeholders. That's why there has been a public online consultation kicked off, and it will be open quite a long time until March next year. And all the stakeholders, citizens, researchers, public institutions are invited to take part and let the Commission know what else can be done to be sure that the EU regulatory landscape is fit for purpose. And you can expect some analysis of all these outcomes over the next 1.5 years. And I think I will leave it here because you want to hear also from the colleagues who spent last couple of months looking at all the pieces of legislation and trying to figure out what they could advise to the Commission could be changed. Thank you.
Thank you so much, Jirka. We have already received a ton of questions. It has been an exciting, super interesting presentation. We will make sure to answer the most relevant at the end of the session. And as you mentioned now, it's time to shift to our next speakers that will present the results of this recent evaluation study. And we will give immediately the floor to Tania. Tania, the floor is yours.
Thank you, Flora. I hope you can hear and see me well. Thank you for the introduction. Good morning, everyone. I'm Tania, and today with my colleagues, Giorgia and Amanda, I'm going to present our study supporting the evaluation of these three key pieces of legislation. And our agenda for today is the one you can see on the screen. First, we're going to present the methodology and evaluation criteria, then key findings per data evaluation, as well as cross-cutting findings and closing notes. To begin with, our three main tasks focus on analyzing how the three pieces of legislation interact in practice, which focused on identifying synergies, tensions, and potential overlaps. These pieces of legislation, the free flow of non-personal data, removes obstacles to the movement of non-personal data across the border. The Open Data Directive promotes reuse of public sector information and stimulates innovation in data-driven services. And the Data Governance Act builds trust in data sharing, sets rules for data intermediaries, and encourages data altruism. Overall, the objective of the study and the primary purpose is to provide the Commission with robust evidence-based foundation that supports the following evaluation of these legislative instruments. Our entire approach was grounded in the principles of the European Commission's better regulation guidelines, and the assessment was carried out against the 5 key evaluation criteria, which is effectiveness, efficiency, coherence, relevance, and EU added value. When it comes to the common set of methodological tools that we applied across the study, we used a mixed method approach that combined qualitative and quantitative analysis for robust real-world insights. And we had 2 main pillars on data collection, which was disk research. We conducted a systematic review of legislative text, preparatory works, evaluations, academic and industry sources to map the context and identify gaps. And we also conducted stakeholder consultation, which consisted of surveys, interviews, workshop to try to capture practical experiences and validate our findings. In this general context, I'm going to give the floor to my colleague Giorgia to follow up. Thank you.
Thanks, Tania. Hi, everyone. I hope that everyone can hear me. I will now continue what Tania started with a discussion on the main findings of our study. To start with the free flow of non-personal data regulation, our analysis found that the Act presents legal uncertainty as the boundary between personal and non-personal data often blurs, and advanced de-anonymization techniques risk pushing datasets back under the GDPR regime. And this leads to risk-averse behaviors that undermine data mobility. Then we found that the implementation progress of the regulation is limited. Most original restrictions on data localization requirements remain. New ones have appeared, and repeals are largely incidental through other legislation. So of the 51 data localization requirements identified in 2020, 41 are still in force, and there are 29 additional potential measures now currently under review. Though many of these fall outside the free flow of non-personal data regulation scope. For instance, 22 of these due to national security reasons. That is an area that is reserved for member states under EU treaties to decide. And this creates a significant, legally permissible gap in the single market for non-personal data. Also, transparency is weak, with only a small number of data localization requirements that are publicly available or formally notified. And as a result, businesses struggle to understand which restrictions apply, and awareness among private sector actors remain very low, highlighting a gap between the regulation's objectives and its practical implementation. Nonetheless, we found that the free flow of non-personal data regulation aligns with broader EU data legislation, complementing the Data Act and the Data Governance Act to ensure a coherent and integrated approach to data governance. Then moving to the results of the evaluation of the Open Data Directive, we noticed several trends. First, that data reuse is rising thanks to the directive's provisions. The share of organizations reporting weekly reuse of their datasets rose from 7 to 27%, while the share reporting no reuse fell from 13 to 3%. However, uptake at the local level remains very low, and small and medium enterprises continue to face barriers to reuse. Second, we found that high-value datasets are rare, as they represent less than 1% of all datasets published on open data portals and account for just 0.3% of total reuse, mainly concentrated in Earth observation and statistics. Also, legal and non-government data still lag behind. We observed that 7% of relevant public administrations report full reuse of legal datasets, and many organizations outside the public sector share very little data. We could conclude with this that access gaps remain, although application programming interfaces, which the directive explicitly promotes, are improving. Their deployment is still inconsistent, and large firms dominate their use. We have a 25% compared with 5% for small and medium enterprises. And this results in a competitive imbalance. Third and last, with respect to the Data Governance Act, the evaluation we conducted was by necessity a baseline assessment of a nascent and still developing ecosystem, given that the Act has been adopted in 2022 only. So the DGA's overall aim to facilitate the availability and reuse of data across the EU by establishing trusted data sharing frameworks has been assessed by our analysis as quite relevant. However, the Act has had limited effectiveness so far due to incomplete application. And this is given to the fact that, first of all, some member states still haven't designated a competent body or authority that enables a few further functions ruled by the DGA. Indeed, although the DGA doesn't require national transposition laws, there are still a few elements that are upon the member state to decide. For example, the specific data opening up processes, the charging of fees for such services, the setting up of penalties for eventual infringements of the DGA, and so on. Secondly, limited effectiveness is caused by the low uptake from the business and other actors concerned. Indeed, we can count on a very limited number of public sector bodies opening up data for reuse, only 27 registered data intermediation service providers, and only 3 registered data altruism organizations. And the low uptake by companies and organizations may be attributed to a lack of awareness of the regime, and most importantly, weak incentives to be a recognized organization under the DGA. Indeed, we observe that in the views of data holders, the costs and burdens of offering the services regulated by the DGA are often believed to outweigh the benefits. Further, internal coherence of the Act has been questioned as well during our study. Due to some uncertainties in relation to the meaning of intermediation services operating within a closed group, which according to the DGA doesn't fall under the regime of data intermediation organizations, but what is a closed group hasn't been adequately defined by the law. And then another uncertainty relates to what exactly it entails for an intermediation service and its client to aim to establish commercial relationships for the purposes of data sharing, as it's laid down in Article 211 DGA. Because in this respect, it's not totally clear if data intermediation requires explicit contracts, regular payments, or may simply facilitate access to data. Also, data altruism under the DGA should happen for objectives of general interest. However, it is up to each member state to define what this exactly means in their national law. So the result is varied definition of general interest across the EU. And this may cause legal uncertainty in the case of cross-border data sharing for purposes of general interest, which at this point you understand that can be different things for different countries. To conclude, at the moment, the EU added value of the DGA cannot be fully determined due to the fact that its objectives and application remain largely unrealized. Thanks for your attention. Then Amanda, the floor is yours for the cross-cutting aspects of this study.
Thanks a lot, Giorgia and Tania, and nice to be online with you all today. So if we go a bit forward to actually what came out of this evaluation, so we look at both synergies in the next slide, but also where they actually complement each other, but also where we see issues or overlaps, such as described by Jirka already for the omnibus. So if we look at synergies in specific, so let's take this a bit more practically. Let's say we have a data set, one on EU climate impact research. So this would cover soil, rainfall, as well as temperature data that could be collected through sensors across multiple EU member states. And let's say this data set, it includes non-personal, but includes aggregated indicators as well as granular sensor level readings. So if we look at this data set from the perspective of the free flow of non-personal data regulation, we see that, of course, this regulation establishes the principle of free movement and non-personal data. And what this would mean for this data set would be that the entire data set, both aggregated as well as granular data, can be stored and processed anywhere in the EU without localization restrictions. And we can see that researchers can run models on EU-wide data sharing platforms, those using cloud services, which are hosted in different member states. If we take the same data set from the Open Data Directive, so we know that the Open Data Directive builds on a pan-European market for public sector data. So if we jump back to this data set, we could see that public authorities could publish aggregated indicators, in this case, average rainfall, for instance, per region, as open data. So this would enable developers to create apps and dashboards, let's say for farmers or policymakers, to make this data also reusable. Then if we look at the Data Governance Act, we see that the Data Governance Act, as already emphasized by Giorgia, creates a new option for sharing data under more controlled conditions, let's say. So if we go back to our data set example, we see, for instance, granular sensor data. And this can be commercially sensitive, and this can be also trusted via intermediaries through this act. So this would allow agri-tech companies, for instance, to access detailed data for precision farming algorithms, while also respecting confidentiality of the data. So if we take this whole, as a package, we have one data set, 3 layers, and we see that the NDP, so the free flow regulation, open data directive, as well as DGA. So one would allow the free movement, the second would open aggregated data for reuse, being the open data directive. And then we see that the DGA would allow controlled sharing of sensitive microdata in this instance. So if we go a bit more into, let's say, the cross-cutting issues that we found through our research, we see 6 key challenges, you can say, that we pointed out here, and that also supports the EU's ambitions for Omnibus. So the first one, we see unclear data boundaries. So we see a bit of a ambiguity in regards to data classification. So to specify a bit more, the boundary between personal and non-personal data appears to be unclear, especially with new de-anonymization technologies, which also make it difficult to apply the free flow regulation. And if we go to our second one, so that this is more of a gray zone between the different laws. So we see public sector bodies face a bit more uncertainty over whether certain data sets fall under the Open Data Directive or Data Governance Act, particularly for mixed data sets. And as someone who works in data security, I see this quite a lot with our clients as well. This is quite a struggle that a lot of organizations face. Then we also go to conflicting cost models. So the Open Data Directive specifically promotes free access. Then we have the Data Governance Acts that allows fees for reuse of protected data. And this creates incentives for monetization and also limiting free data availability. Then if we go to the fourth point, so this would be more of a fragmented governance. So we see that multiple national bodies manage different instruments, of course. Single information points remain incomplete in this sense. And we also saw that many member states have no designated competent authorities in managing all of this, or at least not every member state. And if we go to our fifth, so we see complex global rules. So if we look more from the international data flow complexity, we see quite a few divergent approaches here. So we see the Open Data Directive encourages global openness. Then we have the Data Governance Act, and that introduces safeguards for third country transfers. And then we have the free flow regulation, and that focuses on intra-EU. And this can lead to a perception of complexity, which was already emphasized by Jirka earlier regarding the omnibus as a solution to this, of course. And lastly, but certainly not least, we saw quite a few inconsistencies with other regulations. So if we look at GDPR, for example, and mixed data sets, we see diverging definitions there. So for example, we have what is defined as a data holder, and then we have data subject. And we see unclear criteria for anonymization under the DGA, so the Data Governance Act, which creates some compliance fears, especially for those working in the banking sector, for instance, where compliance is quite important. But also looking at sectors such as the public sector, where data is very critical to maintain. So most data sets are mixed, personal and non-personal, and this is also causing public bodies to refrain from sharing unless there is clear guidance to do so, of course. And we also see the need for incentive for sharing to be provided, especially within the Open Data Directive. We actually had an expert focus group there where this was quite thoroughly discussed. So if we go to our next steps, indeed, we see, well, of course, the omnibus is quite a large next step in terms of EU data regulation. So what we see is a need for consolidation and not per se deregulation. So instead of having 3 separate laws, the EU is looking to combine them into one law. And then what we see as well are core protections to stay. So it's good to note, and also expanding on what Jirka added earlier, that safeguards are still to be enforced in regards to data regulation to ensure both cross-country data sharing in a secure manner, but also protection of trade secrets from leaking, both within the EU, but also to non-EU. So ensuring that our data is safe, but through a more consolidated, let's say, approach. So that actually closes our presentation today on our findings from our study. It was quite a long study, starting already in February. So as you can imagine, we have many more findings to share. But we hope that this gave you a bit of an insight, and very happy to answer any other questions on this. Thanks a lot.
Thank you so much, Amanda. Thank you, Giorgia. Thank you, Tania. I think now it's a great time to move to the Q&A session. And I invite all of our speakers to open their cameras. We obviously would not be able to go through all of the questions have been shared with us today. We're thanking you for this amount of interest that you have shown, but we will try our best to answer them on the report out. So I see everyone's cameras are open. We can already start with some questions for Jirka. There was a variety of questions touching on different elements, from the data labs to the standards of the high quality standards of the data sets. Many questions were related to the private sector. For example, we received a question on how what is EU doing to attract private sector interest in order to make data spaces more commercially viable. And if you could also elaborate on the support available for companies to translate the regulations that you mentioned into practical applications.
The first question concerned with the data spaces, but it's difficult to speak about all the data spaces in one sentence, because they are all a different stage of development. Some of them are in the stage of being designed, some of them are in the stage of being launched, and some of them are a bit more mature already and creating value for the members of the data space. So it's very difficult to say something that applies to all of them at the same time. And what the Commission can do is to create a regulatory environment that does not create barriers for companies that would like to be part of a data space. On the other hand, that it creates value for them to be there. And this is exactly what we are trying to do with the changes to the regulatory landscape right now, and with putting in place some further measures like the data labs, which are quite extensively treated on in the data union strategy.
We can move on to the questions for Tania. Tania, in your study, did you also take into account the findings from the European Research Area study on improving access to and reuse of research results, particularly its assessment of the fitness for purpose of the Open Data Directive, the Data Governance Act, the Data Act, and other related instruments?
Thank you, Flora, for the question, and to the person that was addressing it. From our side, on the free flow of non-personal data, I think our scope of this research that we conducted was a bit more restricted, also focused more on the differences between personal and non-personal data. So the actual document that you mentioned wasn't consulted by us. I would invite my colleagues maybe to mention if they based any of their findings on it, but I think that would be it from my side. Thank you.
Thank you, Tania. Also, now moving to a question for Giorgia, we received quite a few questions on the part of your presentation. I would like to ask you, how do you ensure that the category of businesses includes a representative sample from a wide range of companies across a variety of industries? And in general, how did you ensure that you are measured the data reuse within this study?
Yeah, at this point, I guess that we need to distinguish the fact that I focused on the Data Governance Act. So when we talk about the business that has been consulted for the evaluation, we mainly included data intermediation providers that registered in the EU register, and then some companies that are trying to be registered. For the reuse, we basically asked for feedback to public body and authorities, as the DGA established to be appointed for this purpose. So I guess for the business part under the reuse is someone else better placed to reply.
Yeah, perhaps I can expand on that also from the Open Data Directive side, for which Capgemini was a bit more active on. So we used quite a few different approaches to gather this data, both from surveys, but also expert focus groups. So we made sure that in our sample to include both micro, small, but medium and large enterprises, and we reached out to a very large number of these, in the hundreds actually, and then we wound up getting responses of about, I would say 150 overall, across surveys, expert groups, etc. And we also looked at European statistics, both from the EU data national portals, in order to actually contextualize and also to triangulate the data to ensure that the findings also work well together and can support conclusions in that way. I hope that answers the question.
Thank you so much, Amanda. Maybe now going back to Jirka, we have received quite also a lot of questions related to the digital omnibus proposals. And one in particular is asking, why did the Commission decide to proceed with the digital omnibus proposals in parallel with the ongoing fitness check of the digital rulebook? And could this lead to the reopening of the same legislation again after the fitness check concludes?
That's a very good question. Well, the digital omnibus is tackling the issues that were quite apparent already over the last year, or the first year of the new commission, which is just now concluding. And it made sense to tackle them as soon as possible. And I would not say that the digital fitness check was running in parallel. No, it's starting right now. And it will also be looking at a probably wider scope of issues and in more depth. And that's also something that the digital omnibus is not doing. It is, for example, when it is merging the rules on public sector data sharing, it is doing mainly that without rewriting them, even though we noticed some ideas for some substantial changes or legal reformulation of various issues. But we wanted to keep the rules as they are for the moment, also to make it easier for member states to agree on it, to agree on something that basically in substance is the same, but making it more coherent by putting the different rules in one legal measure. And then the fitness check will be then looking at more in-depth substantial issues if it turns out that there needs to be some more substantial change. It can be addressed later. But the digital omnibus is really addressing the issues that were clear already now. It would be good to change, such as since 2 years, the Data Governance Act is in application. Turns out that data intermediation services, data altruism services did not kick off that much in Europe. That's why it's probably time already now to relax a little bit the rules that were imposed on this kind of services. It's also something that you find in the omnibus. For example, the obligation to be certified and notified before you can even start a business. So all these were relatively clear things that were, it made no sense.
Thank you.
And last thing, I saw a question concerning some impact assessment and some underlying facts for the different changes. So besides the evaluation study that the colleagues have presented and which will be published at the beginning of next year, it's almost completed, and it will be published once it is completed in January. There's also the staff working document, which you can consult if you are interested in learning a bit more about the background for the digital omnibus. And you find a link at the webpage that presents the digital omnibus. It's called the staff working document, and there is a bit more information about different changes. Over to you, Flora.
Thank you so much, Jirka. Really interesting discussion. I think we could have stayed here and discuss for a lot of hours about this aspect. As we are approaching on the end of the session, I would like to thank all of you for your time today, specifically our speakers. We will make sure to ask all additional questions to them and maybe share them together with the recording and the slides on a recap report. In the meantime, and as we're closing this session, let me remind you that this is not the last webinar of the year. We are going to close this year with the next webinar on the European, on the use case observatory report, and So two real use cases, two presentations, and how they use open data to innovate. And obviously, as we have seen you being so talkative today, we would love for you to continue the discussion on the collaboration channel. We have a dedicated section on the European Data Portal for this particular webinar. So we totally encourage you to go on the collaboration channel and continue the discussion. And with this, I would like to close on this slide. We really would like to see to receive your feedback and what you would like to learn next. I'm pretty sure that we are going to have an additional session on this topic and further deep dive on the data union strategy and the latest updates on the legislation aspect. I want to thank all of our speakers today for their time and their effort. And as promised, everything is being recorded. We will share the recordings with you. We will share the slides with you, as well as try to answer to the additional questions you shared with us. And with this, I would like to thank you all. I'm wishing you a nice day ahead and a nice weekend. Thank you very much.